All right, I think it's slowing down on my end.
Great, thank you, Kelly. Good afternoon and welcome to the last session of the spring conference by Southwestern Commission Area Agency on Aging. And we're so glad that you have decided to join us for this afternoon. We have enjoyed all of the information that we've been able to provide for you over the last 5 weeks, and this session as well. We have some great experts in the field of guardianship that are going to open up their brains, as I say, and give us what they have. So we're excited for that today. And so without further ado, I'm going to introduce them, and then we'll turn it over to them, and then we'll do some things at closing. So we're excited. I'm excited to introduce to you Linda Kendall Fields. I've known Linda for a long time. She is a clinical associate professor and program coordinator for UNC Cares at the UNC School of Social Work in Chapel Hill. Y'all know that little school down there in Chapel Hill that's red. Wrong. She's dedicated over 35 years to building communities that are responsive to the needs and contributions of older adults, people with disabilities, and their families. In her capacity at UNC Chapel Hill and as coordinator of the CARES program, she's been leading several initiatives aimed at increasing greater choice and self-determination through systems change. This includes the statewide Rethinking Guardianship initiative, which she will give us some information about today, which has been in place since 2015. So welcome, Linda.
Thank you.
Then Hunter Plemmons graduated from Campbell Law School in 2009, having obtained top honors in the subjects of wills, trust, and estates, professional responsibility, and ethics. He practiced wills, trusts, and estate law in Asheville until accepting the appointment as Haywood County Clerk of Superior Court in 2017. And we welcome you as well, Hunter. I do have just one or two things. Those folks that have been with us before know to put their questions in the chat. I'll be monitoring the chat and we'll forward to our presenters at the appropriate time if you have questions. And of course, we will have questions at the end as well. But Hunter, the stage is yours, and thanks so much for being with us.
Yeah, thank you for having me today. As you said, my name is Hunter Plemmons. I'm the Clerk of Superior Court in Haywood County since 2017. I was appointed to this position after the longtime Clerk of Court, June Ray, retired. And so it's kind of been a long and winding road to get to that point. But you mentioned that little school in red down in the eastern part of the state. So I actually went to NC State undergrad in engineering, and somehow ended up in law school, and then ended up back home here in Haywood County serving as a clerk. So, but I feel right at home here, and definitely enjoy my work here in the Clerk of Superior Court's office. So I just wanted to, I made a little outline here of what I wanted to talk about today. And then of course, feel free at any point during this presentation to interrupt me with questions, or you said you were going to be forwarding me with questions, but I'll be happy to take those throughout the presentation or at the end of my presentation as well. We can answer those at that time. But so many folks probably don't know what the Clerk of Superior Court's role is when it comes to guardianships. But North Carolina is very unique in that setting, in that most other states, or actually every other state, has a separate elected official who serves as the kind of the judge of probate, which typically hears these guardianship matters. But in North Carolina, the Clerk of Superior Court actually serves that role as well. So aside from keeping track of what happens in the courtroom, collecting every document that's filed at the courthouse, helping the public, keeping track of all the money that comes through the court system, the Clerk of Superior Court also has that responsibility of hearing the guardianship cases in that county. And so I have, every county has one elected clerk of superior courts. And those counties are given assistant and deputy clerks based on basically how busy that office is. So there's a workload formula that goes into that and kind of determines how many staff each county has. So in Haywood County, I have 20 staff that work underneath me that I'm responsible for managing and ensuring that all of our statutory duties are carried out here in Haywood County. And that's probably, well, it is the largest county and the busiest county west of Asheville. So west of Buncombe County, excuse me. So Haywood County is part of these 7 county districts here out west, and definitely the largest county by population in the district. So when I came into the role as clerk of superior court, I obviously knew that I was going to be serving in that role as judge of probate, and had a familiarity with guardianship proceedings and incompetency proceedings. But I quickly realized that there was a whole lot of on-the-job training that needed to take place too, and really, aside from just learning the law and the technicalities of guardianship proceedings, I would also need to spend a lot of time learning about the just the family dynamics that come into the courtroom in these proceedings, just kind of those intangibles that come along with these proceedings, because you quickly realize the weight of the decisions that you're going to be making as a clerk of superior court in these proceedings. So it doesn't, it's never lost on me that when I have to adjudicate someone incompetent, even to a limited extent, I'm taking away that person's rights to make decisions for him or herself, right? So that's not a decision that's taken lightly. But the clerk of superior court really in these guardianship proceedings is responsible for a couple of different things. So when someone files a petition in my office alleging that someone is incompetent, I first, in the hearing setting, the first thing we have to do is decide whether or not that person actually is incompetent, right? So, and what does that mean? Well, the law states that that an incompetent person is one who lacks the sufficient capacity to manage his or her own affairs, or to make or communicate important decisions concerning their person or property, right? And that can be due to a lack of capacity due to mental illness. The statute actually lists a few examples of that. So mental illness, intellectual disability, cerebral palsy, autism, inebriety, disease, etc. Those are just some examples, but they're not limited to those things. So first I have to make that decision as to whether or not that person lacks the capacity to make those healthcare decisions, for example, or can this person decide whether or not is he or she able to make a determination as to where he or she should live? Or is this person unable to manage their financial affairs due to some kind of mental or physical inability, right? That's another example where the person can be found unable to make those decisions. So we look at the financial aspect of things, and we look at those personal decision-making aspects of things as well, and really look at the medical evidence, look at the testimony of witnesses, and really decide whether or not that person can make those decisions for him or herself. And I'll get into a little bit more about how I approach these things in a little while, but that's just a basic definition of incompetency. And I know that there's a lot of debate and a lot of desire out there to change the wording in some of our antiquated statutes, but I'm just using the statutory language right now. And then let's say, for example, that we've determined that a person is incompetent and cannot make decisions for him or herself. Then we move on to the second step in the process, and that is who should be appointed as guardian for that person. Who is in the best interest to serve as guardian for this person, and then and to what extent should that person serve, right? So this person that's serving as guardian might not be the incompetent person might not need someone to help manage his or her financial affairs, right? They might have the complete ability to do that, but they may not be able to make medical decisions for themselves for whatever reason. And so you have to consider all aspects of the guardianship and decide whether a full guardianship is needed or whether some sort of limited guardianship is needed. And again, going back to the discussion before on the incompetency, if the person is not incompetent, right, then we wouldn't proceed with appointing a guardian for that person. And throughout these guardianship proceedings, especially from my perspective, one of the most important people in the room in these hearings is the guardian ad litem, right? And so the statutes provide that every person who's the respondent in these proceedings is entitled to a guardian ad litem attorney. And if they can't hire their own attorney, they don't have the means to hire their own attorney, for example, it's required that one is appointed for them. And so we have a list of attorneys here in Haywood County, and even some outside of Haywood County that serve here sometimes, that are well-versed in the guardianship laws, and their primary responsibility in these proceedings is to interview everyone that's in this person's bubble, right? So talk to the respondent especially, find out, drill down into what, where this person may need some help, or where they are kind of lacking in capacity in certain areas. Interview the family members, get an idea of how this person lives day to day, and determine really what this person's desires are, right? Because the law is written in a pretty strange way in North Carolina, in that this guardian ad litem attorney is responsible for making a recommendation to me as the judge in these proceedings. The guardian ad litem has to decide what is in the best interest of this person from the guardian ad litem's perspective, and then also what is the respondent's desires and wishes. And so all of that is equally important, right? Or even, you know, sometimes of course, the respondent's wishes are most important, but that guardian ad litem is responsible for writing a report and presenting that to me in the courtroom setting to really educate me as to the day-to-day life of this respondent. And then so sometimes a permanent kind of guardianship is not needed. Sometimes, for example, there might be a severe mental, or excuse me, a severe physical or mental impairment with this respondent, where an emergency guardian might be needed, and that's called interim guardianship in our statutes. And so, let's say, for example, that someone's in a car accident and in a coma in the hospital, and obviously can't make medical decisions for himself at that point. Well, the spouse might be appointed guardian to make those healthcare decisions on an interim basis, especially if it's determined that this person might be able to recover in the short term, such that he can make those decisions moving forward. And so it's always appropriate to consider whether this is just an emergency situation where someone might just need some help in the short term, or whether this is likely a more permanent situation where a permanent guardian is needed. And I say permanent, I don't mean that that it's set in stone, right? Permanent just means that the person is in fact adjudicated incompetent, a guardian's appointed, and and then as I'll discuss later, we reassess the situation throughout time to determine whether that guardianship is needed as we move forward. So that was a lot of law and kind of background into what I'm considering in these cases. But let me just talk before I talk about my approach to guardianship proceedings, let me talk about my background and kind of what impacts me from a personal level in these guardianship proceedings and how I approach these hearings. So first of all, one of the earliest impacts on my life in this area would be growing up with my mother as a teacher's assistant in elementary school, right? And so she, for whatever reason, when she first started, was placed in the special needs classroom. And within a few short years, she was actually placed in the severe and profound special needs classroom. And so I, on a daily basis, going to that elementary school and hanging out with my mom after school and in breaks during the day, I got to interact with these individuals on a daily basis. And even though we were dealing with some of the most special needs, severe and special needs that individuals can have, it gave you insight into the personhood and the fact that everybody has worth and everybody has needs to be live life to their fullest, right, and have every opportunity that everyone else gets to have. So that obviously made a big impact on me from an early standpoint, and impacts me in the decision making that I have in these guardianship proceedings. And then also another thing that impacted me was that my parents, when most of us were in high school years and they were done raising the 4 children that they biologically had, decided to step in and help my aunt with her child. And he was about 6 months old when my parents decided to take him into our household. And it was obvious that he needed help that his family could not provide. He was severely neglected as an infant and had some behavioral and healthcare needs that his family could not provide for him. And so that began an 18-year process of helping try and find the treatment and medical care and support that my brother needed to make it in life. And so when he turned 18, as he approached 18, it became clear that he was not able to make the important decisions in life that are needed. So he was actually, my parents who live in Madison County were actually appointed as co-guardians to make residential and healthcare decisions for him as he approached that 18-year mark. But I also saw that with finding the resources and the help and the therapy and the medical care that my brother needed to make progress and improvements in decision-making skills, he was able actually at age 25 to restore his competency and terminate that guardianship. And he now lives in an apartment group home type setting with another individual where he fully has his rights. He's able to work and able to go to the doctor and make those decisions that he wasn't able to make when he was 18. And so that impacts the decision making that I have in the courtroom, because I see that that people can improve over time with the support that they need, and that it's a constant need to review these cases for the necessity of a guardianship. And then finally, this is a case where I mentioned earlier where sometimes it's important to appoint someone as a financial guardian of the estate, but not necessarily as a guardian of the person. So many of you may have seen seen instances like this, but even with family members. But a couple of years ago, my grandmother, who in her mid 80s, started falling victim to these phone scams and internet scams. And just through luck, did my mother determine that or found that thousands of dollars was going out of my grandmother's checking account every month to purchase gift cards for someone who was stuck in jail overseas, right, and just needed that money to get out of jail to get home. And so no matter how much we talked with my grandmother, no matter how much we were trying to convince her that this was a scam, she was not able to comprehend that, right? And it was just a constant addiction, not necessarily an addiction, but a constant need in her life to provide for this person that did not exist. And so my mom and her siblings made the difficult decision to apply for guardianship. There was no power of attorney in place or anything like that for financial reasons. And so this case was filed in Buncombe County, and my grandmother was adjudicated incompetent with respect to her estate, but fully able to make residential decisions, medical decisions, and so forth. But it was just, for whatever reason, there was some slight dementia there, that she was just not able to comprehend the financial aspect of things. So none of my family members wanted to serve in that role as guardian for my grandmother, but so a third party entity was appointed as guardian of her estate. She still lives alone by herself at 85 years old, makes the healthcare decisions and residential decisions for herself, but just has that extra help from a guardian to manage the money for her on a daily basis. And everything's been working out smoothly with that. So again, this is another case that's impacted my life, because I can see the need for guardians in certain circumstances when there's no other alternatives in place to manage things. So with that being said, my background, let me talk about my approach to these guardianship proceedings. And I've talked about some of these along the way, but just a few things. Number one for me is that in all guardianship proceedings, if I determine that a guardianship is needed, I want to set or establish the least restrictive guardianship possible, right? So that's why it's important for me to look through every area on the form, right, that a person can make decisions for him or herself, and really determine what is it that this person needs assistance with, and what can this person reasonably continue to make decisions for themselves on. And then I'll look, of course, whether there's alternatives to guardianship, right? I'll look at whether there's a power of attorney already in place, whether even if there's a power of attorney in place, sometimes the individuals we deal with are aware of those powers of attorney and can work around them, right? But is it appropriate in this particular case that a power of attorney meets the needs of this individual? And if so, a guardianship would not be needed. And then, as I mentioned earlier, on interim guardianships, these emergency type guardianships, I really use that as a tool, especially in these emergency type cases, to sometimes extend those emergency guardianships up to 90 days, which I can under the law. And then hopefully within that period, restore that person's rights so that they can not be branded incompetent and continue to have these status hearings in the future to determine whether or not they've restored their competency. And then, of course, one thing that I do that a lot of clerks are starting to do, but I feel like it's very important and helpful to me, is that I routinely set status review conferences for all of my guardianship cases so that I can keep a handle on what's happening in that person's life. Usually, if it's clear to me that there's a strong possibility that this person can make progress over time, I'm setting status review hearings at 3 to 4 months and bringing them all back into my hearing room to interview the family and talk to the respondents and just and see what's happening in their lives to see if the guardianship is still needed. And then some of you may, there's a few new updates to the law over the last few years that allows for, kind of temporary guardianships. Like, for example, if a person needs assistance in applying for government benefits, and that might be the only thing that person needs, I can set a temporary guardianship to appoint someone to help that person apply for those benefits and then terminate that guardianship afterwards. So there are other tools available to clerks to not set these permanent guardianships in place. So with all that being said, I would just like to say that from my standpoint, and I know that you all are here because this interests you, and you might have loved ones that are involved in these types of situations. But the thing I see most that's most needed in our communities, and I'm sure you're aware of this, is just education and resources for families, right? So many families come into my hearing room expecting me, to establish a guardianship and to point them in the direction to all the available resources, and that will solve all their problems, right? But that is not the case. So for one, I can't advise them on their resources and what they should do because I'm serving as the judge in the case. I can't advise them on what to do. But it would be so nice if we can focus in our communities on pairing these families up with government and local resources that because a lot of times they come into my hearing room just lost and just searching for answers, and it's not, and those are not answers that I can provide them. So thank you for letting me present to you. Obviously, this means a lot to me. I take this very important in the Haywood County Clerk's office. If you ever have any questions or concerns or want to talk about guardianships in general, feel free to come by and see me, and I'll open it up for any questions.
Thank you, Hunter. That was amazing. We appreciate you being willing to share some personal information about yourself and your family too. That brought a whole nother component into what I had envisioned this session to be. And we appreciate your willingness to do that. It certainly does make it different on some level. It makes it human on some level. Certainly folks come in and come to our office and don't know what to do or where to turn and those kind of things. So yeah, we understand and we hear you. Does anybody have any questions? Here's a question. What safeguards can be put in place so a guardian can't drain a person's assets?
Yes, that's a good question. So with guardianships in North Carolina, the law requires that every guardian be bonded, right? And so it's the clerk's responsibility to make sure that a guardian that's managing someone's money has the appropriate bond in place so that if there is theft or if there is misappropriation of funds, that bond's available to reimburse the guardianship. And then also we have yearly accountings that come into the clerk's office where we're keeping a pulse and keeping track of what's happening in that guardianship estate. And it's the clerk's responsibility to review and audit and approve of what happens in those guardianship estates each year.
Hunter, this is Linda. I was thinking it might be helpful to just go over the different classifications of guardian of the person, guardian of the estate, and general guardian. Just.
Oh yeah, sure.
Mm-hmm.
Yeah. So a general guardian is a guardian that is responsible for making the personal decisions for someone, the medical, the healthcare, residential decisions, as well as the financial decisions for a respondent. A guardian of the person is someone that has the ability to make those decisions about the respondent's person, but not the finances. And then the guardian of the estate is a guardian that makes the financial decisions, but not any personal decisions for that respondent.
And correct me if I'm wrong, Hunter, that is relatively new. I mean, I don't know the years, but back of this, you either had all or nothing. And then several years ago, and again, I don't know how long ago it was, it became that you could do a general guardianship or a limited guardianship or financial, the ones that you listed. That hasn't always been true. It used to be all or nothing. Am I correct in that?
Linda, you could probably speak better to that than me. I'm not
I'm really not familiar with that, Sarah. I think what I would, and would have to dig quite a ways back. I know the latest largest change to the law was in 1987. So I would think it would have to be before then, if that was the case.
Yeah,
But-
probably was,
but-
Linda, but it was, I mean, again, it's been many years ago, so.
It may also, and I can't speak directly to that. This is the first time I've heard it. But what I can say is that you've got such a jewel in your clerk of court in Haywood County, in that so much of the way he practices is really gold standard for guardianship practice, as we understand it, as a national and even global trend, because the vast majority of guardianships are what we call full or plenary guardianships, where basically judges, and in North Carolina, that's the clerk of court, who has exclusive jurisdiction over their county. So there are 100 hunters, but they're not all hunter, practicing in North Carolina. So the approach is going to vary some. And so nationally, it's true. And certainly in the statistical work that CARES did in the early stages of our grant work, most guardianships are full plenary, not built from a limited, kind of what's the least we can do, but let's just do it all.
Do it all. Okay.
It's
Okay.
partially a practice difference, I think. But Hunter, what do you think? Is that a fair assessment?
I mean, I think traditionally that's probably, I don't know about the law, since I've been as clerk, the law's been the same, but I think that historically and traditionally, you're right, even in North Carolina, that the default was we're going to have a full guardianship.
Mm-hmm.
And I think that now the focus is how can we limit these guardianship as much as possible to just meet the actual needs of the respondent.
Okay. All right. We did have a question that said limited guardianship with a question. Does that answer that question for you, Lisa? Or do you need more?
I just felt like people needed to know that although it could be general guardian or guardian of the person or guardian of the estate, there are, and our clerk of court in Haywood County certainly recognizes that some people are able to do some decisions, but not others. So on the actual guardianship order, they put what the limitations are. So that does give the respondent some rights. So Hunter's really good to make sure that we don't just take everybody's full rights. So and they touched on that. I just wanted people to understand that, that is a real good thing for guardianship, because I might be able to decide where I can live, but I can't make medical decisions for myself. So I think it's very important to the respondent, the incompetent person, to have some of their rights maintained.
Yeah,
Absolutely. Yes.
one more point on that is that nationally, and I will say globally, the push is to begin with having rights and taking them away sparingly. Whereas right now in North Carolina, the law has it so that the first thing you do is take all the rights away, and then you add them back in. So
Okay.
We're in the process of turning that around in North Carolina, and the clerks are doing a great job, really, of I think, don't you think, Hunter, sort of catching on and having these conversations and beginning to think a little differently than they did even when Rethinking Guardianship began in 2015.
Yeah, I think there's more momentum in that direction than there has been since I've been a clerk. Yeah.
Good. All right. So we have two more questions, and then we'll let Linda take the floor. Does a more recent guardian of the person order put in place supersede a healthcare power of attorney put in place prior to the adult losing capacity? Or will that healthcare power of attorney still be active in addition to the guardianship decision-making power? Do I need to read it again?
No, that's a very good question.
It is.
I can't wait to hear Hunter answer.
Well, You're putting me on the spot here to know the actual law, but Linda can correct me because she's probably studied this, but so from my standpoint, I feel like my order should supersede everything, right? But that's not the way it happens. So I think that the statutes talk about the fact that it's anticipated that the healthcare power of attorney and guardian of the person will work together unless there's a dispute, and then there can be. I have had hearings before to terminate or suspend healthcare power of attorneys in favor of the guardian, but I don't think that the guardian of the person automatically supersedes the healthcare power of attorney. Am I right on that, Linda?
Well, I think you're right on the fact that really the clerks of court have exclusive jurisdiction, in their counties, and therefore they really can make determination. We presently have a bill before the General Assembly that passed the Senate, just flew through, thrilled, which I'll go over later. But it does basically specify that a power of attorney must be, really honored in that role, unless there's a bad actor playing the role, of power of attorney. You need to get that superseded. Presently in the law, if a person is ruled to be or adjudicated incompetent, the clerks have no recourse but to assign a guardian. And we're suggesting some changes, and it's written into the proposed legislation. But it does spell out that the first consideration when they're thinking about, okay, the person has been adjudicated incompetent, the first order is, are there any powers of attorney and written in, legal instruments? And that would be the first priority considered by the clerk. But yes, if the clerk looked at it and said, this power of attorney is ripping off his mother or whatever it is, that needs to be taken into consideration too. So hope that helps.
Absolutely. All right, we have one more. Can you have more than one guardian? One for a state and another for a medical purpose?
Yes, you can. Yep. And you can have, I've seen it to where we have two co-guardians of the person and two different co-guardians of the estate. So you can really set that up in the best interest of the respondent.
Thank you. Any more questions before we move on to Linda? All right, hearing none. Go ahead, Linda. Thank you.
Thank you.
Okay, thanks so much, Hunter. That was great. And honestly, I spent a little time with Hunter and other clerks and folks at the North Carolina Guardianship Association conference earlier this month, and really appreciated how mission and value driven Hunter is, along with, many of the clerks that are practicing these days, and just feel really honored to be, part of this conversation today. And I just wanted to say, I have a PowerPoint, so I don't know if I have the ability to share a screen, but I wanted to say some of the resources that you're looking for are contained on a very user-friendly Rethinking Guardianship website, which you can just Google at any old time, Rethinking Guardianship NC, and you will find all sorts of resources and, frequently asked questions. What is guardianship? What are alternatives to guardianship? The Rethinking Guardianship group also created several years ago, and you can look this up. It's on the Administrative Office of the Courts website. And I just made a note to myself that we should link it to our website, Understanding Guardianship. It was specific to families who are taking on guardianships, especially guardianship of the person, which has been probably the least monitored in terms of, private guardianships that go on. So that what I really want to do with my time is to just underscore the seriousness of guardianship and what it really means, and what we have learned through Rethinking Guardianship, and what we've done, and then find what
You should be able to share your screen if you so choose.
Okay, I shall do that. I'm doing my prefatory remarks, and then
My apologies. I just wanted you to know.
No, that's fine. And I need to watch my time too, Sarah. So feel free to interrupt me if I get all into it and lose track of time. Okay, so anyway, I'm going to try to whip through these slides, and then I don't know if I'll have time to actually show you the website because it is filled with jewels and it's very plain language. We developed it for the Council on Developmental Disabilities. So we wanted the reading level to be that of, for someone who has a developmental disability. So you will find many of the resources being written in plain language, and losing a lot of the legalese which can be a real hassle for folks. So let me it says host disabled participant screen sharing. So try it again, multiple. Yeah.
Linda, I'll just briefly make you the host and then you should be able to share.
Okay. Yep, I can do it that way too. I still don't have, I am the host now. Oh, I feel so important. I'm the host.
No pressure.
All right, I should have brought cookies or something if I'm the host. All right, let me just show you my PowerPoint. Give me a second to put it in presentation mode. And now let me know if you can see it. Can you see it? All right. So I just want to celebrate really going on 8 years that Rethinking Guardianship has been changing the culture around decision-making and us. And really, Hunter, you heard Mark Kleinschmidt say it. He's the clerk of court in Orange County. He said, Rethinking Guardianship is responsible for much of the change in the conversations going on at the clerk's office, and really bringing things forward to really, I think, honoring people's choice and self-determination whenever possible. So Hunter shared his stories. These are my stories. These are the people, the first woman I met as a newborn, Mary Linden, went on to be a speaker for the Americans with Disabilities Act. Her testimony was shared on the floor of the Senate in 1990 when it was passed. My cousin, who I call my sister cousin, Becky, and her husband, who live in Minneapolis. And she was one of the first mainstreamed persons, meaning before 1975, people with disabilities went to different schools, and then they started going to the same school. And then my dear parents, who have both since passed, who had the wherewithal and the foresight to set up powers of attorney. So number one lesson here for everyone 18 and over, get your advance directives in place. Powers of attorney. Choose who you want to take care of your finances and take care of your health care decisions and other important residential decisions should you become incapacitated. I have said, and I really hold to it, that people should have to do this when they register to vote, when they're 18. You just never know. I could go on and on about these people and what I've learned from them, but suffice it to say they've fueled my entire life's purpose. So I just wanted to say that there's this continuum, right, between full and utter autonomy all the way to guardianship, where you really give up your autonomy to somebody else's decision, and a huge area in between called supported decision making. So autonomy, everyone likes it. Everybody wants to make their own decisions. It's inherent into our basic rights. And so guardianship is an option that should be considered as the last resort. Again and again, last resort. And if you think about it, no one is fully autonomous. Who helps you with important decisions? Do you treat yourself when you're sick? Really sick? I know you do until you're really can't do it anymore. Or I know when I'm making a decision like to buy a car, I will seek out my brother, who's just like a fantastic negotiator. So none of us really live in a bubble in our islands unto ourselves. And this idea that someone can just do it or not do it, it's not really the way life works. We don't either make decisions or not make decisions. we make lots of decisions and have lots of communication and Google it and research it and talk to people before we make important decisions. So how would you feel if your right to make decisions went away? Imagine you wanted to live in the house you lived and you got some kind of nasty guardian. Unfortunately, maybe not nasty, but just had a very different idea and thought that house was not safe anymore and decided you belonged someplace else. That's kind of the extreme of guardianship that can really, has fueled a call for change across the world and in our country and in our state. So we also know that there's study after study that shows that when people have choice and self-determination, they do better. They're more independent, they're likely to work, they're more well-adjusted and healthier. And here's the kicker, they're safer and better able to recognize and resist abuse. Because if you lose your self-agency and your ability to make choices, a kind of resignation, a kind of learned helplessness, a sort of, like, what the heck? Nobody thinks I can do it, so I can. And you fall more victim. So it's counterintuitive because we often set up guardianships to protect someone. And in fact, retaining rights and supporting those rights actually protects people more until you reach a certain point, because guardianship may be needed. And it might be needed if a person doesn't have an interest or ability to make important decisions. They need immediate protection from exploitation or abuse. And in emergencies, when they're unable to give consent, they didn't create a plan, and they don't have advance directives, powers of attorney. Hence the reason for getting those papers in order. By the way, State Employee Credit Union has an amazing deal where you can go and have that done for not very much with an attorney and walk away with all those papers. So we knew, after digging around, we did a lot of early, from 2015 to 2017, we worked with the administrative office of the courts and certain counties in North Carolina to understand what was going on in guardianship in North Carolina. And basically, I'm not going to read all these words, but as you know, it removes an adult's rights to manage his or her decisions and places those with a court-appointed guardian. We, at that time, in we thought about 23,000 adults were probably in guardianship, although guardians of the persons who have private guardians, who comprise 2/3 of the guardians, are private, not public, meaning DSS or county corporate guardians. There's generally no record, unless you have a great hunter guy who is saying, this person needs to be monitored. I want you back in my courthouse in 3 to 4 months. There's nothing that mandates that. And so there are a lot of people out there we don't quite know about. And the records are not kept in such a way that we understand the demographics of that. And then the other bold thing that I didn't take time to look at was that there's a rising issue amongst people 18 and 59 with intellectual and other developmental disabilities and mental health substance use disorders. So you can imagine that is playing a big part in the complexity of guardianship in our state. Very hard. Rethinking Guardianship was funded by the Council on Developmental Disabilities to promote less restrictive alternatives and to create long-term changes in the state's guardianship system. We've worked with stakeholders. I've been the facilitator for this group since early 2016. And we brought everybody together, everyone from the advocates, to the kind of what I call the guardianship abolitionists that say never ever should there be a guardianship, to those who feel that guardianships are the only way, to those who are all in between. And we've had so many conversations, we've done so much study and research, and we've really come together. It's been amazing. It's been great. And these are many of the people and organizations that have been part of that. So we've had all this 8 years of working together through these various grants that you see listed here, culminating, as you can see, our final grant here ends in 2023, but we do have a future still through the Council on Developmental Disabilities. Are making alternatives to guardianship a reality will finish up. So we've worked through 3 primary avenues: collecting data and stories. We've done outreach and education, and we've had a statute writing, legislative, and policy team. And for 8 years, we've been really moving through all this, and it's been extremely complex. Early on, we tried to figure out who's actually declared incompetent in North Carolina. And we found of these 16,000 cases that came through the Administrative Office of the Courts in Raleigh, that 76% of the rulings, persons were ruled incompetent. 22% were non-rulings, meaning they were often being extended or there was another ruling, and only 2% were identified or adjudicated not incompetent. One of the takeaways here is, yeah, maybe people are really waiting to the last minute and someone really has lost all that capacity. The other takeaway is, if you have a hammer, everything looks like a nail. In other words, know that if you go into a courtroom and the judge finds the person incompetent, more than likely there'll be a guardianship in place. But this was looked like very hopeful news to us. Of all those people, 16,000, only 3% even sought restoration, meaning, hey, I'm doing better. Can I have my rights back? Only 3% asked for it. Of those 3%, 70% had some or all rights restored, and 30% remained in guardianship. So also part of the story we began to create was, gosh, it doesn't have to be permanent. You can go back and ask, and letting people know that. I can see I'm really running low on time, so I'm going to go through really quickly, but I just wanted to show Catawba County was kind enough to let us dig through their paper files. Took us 8 days with 4 people to dig through it all. But you can see that most of the folks have dementia and IDD. And you know who these folks are, the IDD? Youth transitioning into adulthood from special ed programs, which surprises a lot of people. But schools, we call this the pipeline to guardianship. Schools don't offer resources to parents saying, hey, you could do it a different way. This is all about ensuring rights and protecting elders. And all these bodies have been working on it on a national basis. Media has been looking at it. You've probably seen some of the worst stories in I Care a Lot, that Netflix film. And those are kind of the most egregious cases that we don't really hold up as an example of why guardianship needs to be changed. But that is what can happen when there's unnecessary and even predatory guardianship that the clerks certainly, are guarding against. We have all kinds of wonderful video stories, and I'm not going to show them to you. This is a marvelous story that I recommend that you watch. We have about 5 or 6 video stories on the Rethinking Guardianship website. Oops, we're not going to listen. And it's also about people with disabilities. This Jonathan Martinez behind us is a consultant for Rethinking Guardianship from Syracuse University. And he was the attorney behind the very public and successful Jenny Hatch case. Jenny Hatch's wonderful comment is, I don't need a guardian. I just need a little help. It was like, really? You're going to just slap on a guardianship because I can't do everything by myself? Many of you remember this story. This is all about guardianship. Free Britney. It's if you see the word conservatorship, you'll see that's basically in California what they call guardianship. So Rethinking Guardianship has been, to some extent, the Free Brittany group for common people living in North Carolina who were not pop stars. But we're not quite as radical as Free Brittany. We have this great story of Sean Brady. I won't go into it except that he found his way to us in a meeting. He was a horticulture student in Alamance County. And he said, I saw the sign saying guardianship. I'm in guardianship and I'm graduating and I've got a job at Home Depot and my stepmom is my guardian and has put me in a group home 2 counties away and I really hate it. And basically this group of people that you see on the screen helped him get his rights restored with that, with a supported decision-making agreement where an attorney basically agreed to help Sean if he reached a certain financial limit to help him make a decision whether it was a good decision or not about using that money. Because the clerk was very, rightly concerned about exploitation. So we've built our common agenda on the US Constitution and the rights of people with disabilities. And we have this common agenda that least restrictive options should be used, that information should be available to all stakeholders, and that there should be accountability in the guardianship system. But we're balanced. We know it's not no guardianship or all guardianship. It's all those grades in between. Jason's a great story of a person who was under guardianship and whose guardian helped him set goals to get out of guardianship. And now he is. And he is so appreciative of the time he spent in guardianship because that person understood their role was to help him live a more self-determined life. So we've been working on this last grant and focusing on youth because that's what the Council on Developmental Disabilities was interested in, and also adults transitioning from to the community from long-term residential facilities. But we've included all parties. We have a tremendous resources on the Rethinking Guardianship website, showing you some of them. Please look at all these different less restrictive options to guardianship, setting up supported decision-making, informal, formal. This is in both Spanish and English, creating ABLE accounts using simple financial tools, creating a living will. All of these, creating a healthcare power of attorney, simple language, psychiatric advance directive. Did you know there is one where you can determine, this is what I want to have done if I lose capacity and, if I've been off my mental health treatment for a while and who I want to take to help me. So am I running out of time, Sarah? There's a booklet in there that has put all that together. There are all these things on the website. I apologize for a yipping dog who wants to come into my room because, hold on just a second. I'll bet it could be raining or something that he gets all tense if there's a gunshot or a thunderclap or something like that. We as a group came up with these 5 areas for change in the law, that people should have a notice of rights, that there should be a mandatory requirement for consideration of alternatives first, that there should be regular reporting by guardians, that we should change the language from incompetent and ward, and some of those definitions that are really out of date that Hunter kind of went through, that definitions of disability are not a good indicator of capacity. It's really, I have that cousin with cerebral palsy. She's perfectly able to make all decisions for herself. So it's more about, that capacity being really determined in a different way and with a lot more respect to personhood. So we also want to look carefully at the role of the guardian ad litem as they kind of play a dual role. they are both looking, they're the eyes and ears of the court, but they also can be misunderstood by the respondent, which is the name of the person before they're adjudicated in the court. They can be viewed as the private counsel who's there to really represent the expressed wishes and desires. And this can set up a conflict. So we are working on that. And we have Senate Bill 308. Please call your representative because it passed the Senate 47-0. We're just thrilled. It has bipartisan support. And the court, the clerks of court are comfortable with it. The North Carolina Bar Association is the organization that brought it forth. And we're going with the first three of these areas. Every person for whom guardianship is sought has a clear understanding of his or her rights. Guardianship is used only as a last resort, and that it gives courts effective tools for review and oversight to make sure guardians are fulfilling their responsibilities. Those are the three things. There's a lot of description within each of those, but we don't have the time for that. I'd be happy to share that if you're interested at another time. We're going to need 24 and 25 to go after these two. And there are reasons for that. But again, I know we have a time crunch. And as I mentioned, rethinking guardianship will not go away, but we are going to really be assisting the resource process for the administrative office of the courts and the clerks in helping the public, in understanding what they have and what tools can be used instead of guardianship, and also to just understand guardianship if that's the way to go. We're hoping to be involved in more statutory reform. We're going to keep the website and the learning community. We're going to work and have some funding to work with developmental centers around guardians and address the educational needs of the social service system. Being the School of Social Work, we're training the social workers and the DSSs who are adult guardians, and working with the clerks and hospital and healthcare system and the general public. So feel free to reach out to me, look at our website. There's a way you can fill out your information and get blogs. We have blogs that come out every 2 weeks that just give you update on the legislation and kind of the latest and greatest articles and thoughts of the individuals. So I will stop my share, and hopefully I didn't overstay my welcome too long.
Not at all. Not at all. Thank you, Linda, for such great information. And yeah, when we first talked to you and you recommended Hunter to be on this session, and we got that all worked out. And then we saw the blurb from the Senate, and I was like, wow, we're on the cutting edge of information and all of those things. That was pretty amazing.
Your group is kind of the first to know in a way. I mean, you really are the first. I think this pairing of your clerk with kind of the work of our statewide group culminating in actual legislation. I will say that I just checked over the Memorial Day weekend with Catherine Wilson and Michelle from the North Carolina Bar Association on the bill. What's happening? It went through. Get it through the House, please. And they're pushing on it. The General Assembly has gotten pretty focused on the budget right now, state budget, and they've put policy related bills to the side for the time being. So we hope they wrap up their preoccupation with the state budget and get back to policy change, because we all feel pretty hopeful that this is going to pass. And if it passes, we're going to all run to Raleigh and have a great time.
Yeah, for sure.
Yeah.
Lots of work and time and energy for folks who sometimes cannot speak for themselves.
Absolutely. We've got some great personal stories of people who've had their rights restored and refer to themselves as their own guardian. I'm my own guardian. I mean, that's what we each get to be as
Yeah.
regular citizens, we get to be our own guardian, and we don't realize what a precious gift that is.
Yeah, absolutely. Absolutely. Does anybody have questions of Linda?
I'll put you on gallery there.
While
Well,
you're thinking for just a minute, I do want to say a few things as we wrap up. One is you'll see the link to be able to access the recordings of our sessions, except for the first one. And you'll remember we made a mistake and didn't record it. However, hopefully in the very near future, there will be a video recorded with some of our staff and the attorney, Agatha Guy, that provided that session that will be available. So we're hoping that that will be available by the end of 2023. So that we'll take that, give that information available as well. And the other thing I would, as we end up, is to remind you of our elder abuse awareness walks. And many of you will know what these shoes mean. We talk about, and I think this is kind of fitting for ending our session, walking in their shoes. It fits with guardianship. It fits with powers of attorney. It fits with those we love, period. But June the 15th is Elder Abuse Awareness. And if you've been in Western North Carolina in our 7 counties, you know that we host walks in every county on June the 15th at 6 o'clock, and we walk simultaneously together. And we were just looking at shirts, and we have over 800 this year. So if you're anywhere close, we would be glad to have you. And you can look on our website for the exact place and time for each county. Correct, Anna? It's coming. If you're interested in being with us on that day. All right. Anything else other than door prizes? We always have door prizes. Anything else as we close? All right. I'm going to turn it over to, thank you, Deborah. I'm going to turn it over to Lisa Allen. She is our door prize queen.
I do like a good prize. Let's see, our first winner, Kelly.
Our first winner today is Kim Marion.
All right, great. There is a vintage CD player, radio player in this little bag right here in a box, and a really nice fuzzy blanket, which we still need right now. It's been a little cool, and a little first aid kit. We will get to you. And if you would just put your maybe address in the chat.
She's Haywood DSS.
Okay, Haywood DSS will get it to you then. All right. Awesome.
Okay, our second winner, and I'm not sure if she's still on or not. If not, we'll have to get with her, but is Sarah Hinnett. Could be saying that wrong, Sarah.
Well, congratulations, Sarah. You're still with us. This kit is really all about organization. There's all kinds of tools and different ways to organize your home. So we will get that to you, Sarah.
Yay! Thank you. Thank you all for joining us. Many of you have been, several of you have been with us all 5 sessions, and we hope that you've learned at least one thing that you can take going forward on your life's journey, wherever that ends up taking you. And always know that the Area Agency on Aging is willing and able to assist in any way that we possibly can through your journey. Please reach out to us. We'll see you soon, hopefully at the walks on June 15th. Bye for now.
thanks so much.
Have a good
Thank you. Bye-bye.